The Supreme Court has ended its 2023 to 2024 term, made a lot of good decisions this year, took up a lot of great cases, and made a lot of really wonderful decisions that made everybody trust the Supreme Court as sort of like an impartial body of the most qualified people to decide the laws of our land. So, now that John Roberts has clicked off the video, I do want to talk about the Supreme Court's term this year. I want to get into some of the cases that I was more interested in. A majority of the cases I won't be talking about, though, so those cases should be on your screen right now. And if you were really invested or really interested in hearing somebody talk about those cases, then sorry, you're not going to find them here. Starting with Alexander versus State Conference of the NAACP. So after the 2020 census, the South Carolina legislature, which was controlled by Republicans at the time, approved a redistricting plan that would have diluted tens of thousands of black voters and would have made an additional district a safely Republican district. So this redistricting plan was challenged for being an example of racial gerrymandering, and a 3-judge panel did strike it down as such. And so the petitioner, Alexander, appealed to the Supreme Court. And on appeal to the Supreme Court, the petitioner, Alexander, is saying, listen, Your Honors, this is not an example of racial gerrymandering, which is impermissible. This is an example of political gerrymandering, which is permissible, and it only has a merely racial effect. So what's the conclusion? Well, in a 6-3 opinion authored by Justice Samuel Alito, the court says that this is not an example of racial gerrymandering. To prevail on a racial gerrymandering claim, you have to prove that race was the predominant factor in the intent of the legislature in redistricting, either to dilute or strengthen a particular racial demographic. The majority did acknowledge that political gerrymandering can look significantly similar to racial gerrymandering, but in these cases where it's a little bit ambiguous, the court decides that it's best to give deference to the state legislatures. And in the majority opinion, Alito also looks at the expert testimony offered by respondents and concludes that that expert testimony was flawed. And this was something that was criticized by Justice Thomas in his concurrence. He said that this is an example of political gerrymandering, but he said the majority didn't need to go as far as questioning the integrity of the expert testimony. Justice Kagan did author a dissent joined by Justices Sotomayor and Jackson, in which she basically said the majority was cherry-picking the evidence that would best fit its narrative that this is political and not racial gerrymandering. Okay, next up is an arbitration case. For all my arbitration heads, stand up. We're looking at Smith versus Spizzirri. In this case, the petitioners are former and current employers of a company called IntelliServe, and they sued IntelliServe on a number of labor law claims. And the case was initially filed in Arizona District Court, Arizona State District Court. The respondent, Spizzirri, motioned to move to federal court, and then once it was in federal court, he motioned to dismiss the case and compel arbitration. So if you don't know what arbitration is, it's sort of like an alternative to like the traditional court system. Basically, in arbitration, you have usually like an administrative law judge or somebody who's like more experienced in whatever the arbitration's about. And it runs like a normal trial. You can have witnesses and things like that, but at the end of it, the arbitrator, or it's usually an arbitrator, not an administrative law judge, the arbitrator will make a decision. It has a binding effect, just like a normal court decision would have. And you can appeal the decision of an arbitrator into court, which is what happened here. They motioned to compel arbitration, and that decision was appealed all the way up to the Supreme Court. Arbitrators are more common than you might think. Usually, if you sign an agreement with like social media companies, for example, you sign up for an account on Instagram or Facebook or whatever other social media thing, TikTok, there's probably going to be an arbitration agreement in there, so that if you have any claims that you want to sue that company over, it will automatically go into arbitration instead of like a traditional court. The reasoning for that is that with a traditional court, you get a jury, and big companies like to use arbitration because there aren't juries in arbitration. And if it's just me versus a social media company or like Apple or Google or something like that, a jury is typically going to be more sympathetic to me as an individual as opposed to the large company, and I'm more likely to get a favorable outcome, and I'm more likely to get a lot more money in a judgment, whereas with arbitration, it's more favored by the businesses because there is no jury. It's just a judge or an arbitrator or a referee, and they make a decision that's usually more balanced in terms of they're not getting distracted by like the narrative that this is the small guy versus the little guy. And so larger companies tend to favor arbitration, which is what we have here. So yeah, usually if you sign, there's a mandatory arbitration agreement in the contract you sign to get your phone, in the contract you sign with your internet service provider, with your social media company. It's a lot more commonplace than you might think. So what happens? Spizzirri removes the case to federal court, so they take it out of state court, and now it's in federal court. And once it's in federal court, Spizzirri says we should dismiss this case so that we can go to arbitration. That's what Spizzirri says. Smith says we should stay the litigation, which means keep it in the court pending the outcome of arbitration. And this is all just sort of an interpretation of the Federal Arbitration Act. That's where these arguments are coming from. So what happens is the Federal District Court for Arizona dismisses the case and sends the case to an arbitrator. So the decision of the District Court is what's getting appealed here, the decision to dismiss and send to arbitration. So the question is, under the Federal Arbitration Act, if you have basically two simultaneous things going on, you have a case in traditional court and you have a case in arbitration, what do you do with the case in traditional court? Are you required to dismiss it and pending the arbitration, or can you have both things going sort of concurrently? And so Justice Sotomayor writes the unanimous opinion of the court, which says that under Section 3 of the Federal Arbitration Act, when there's like a case pending in court and there's pending arbitration, as long as one party requests a stay of the litigation, meaning keep the case in court, then the court has to stay the litigation. And again, this is just an interpretation of Section 3 of the Federal Arbitration Act. It says that a court shall stay proceedings pending arbitration, and the court reads shall to basically impose a requirement that the court has to sort of stay that litigation. Stand up, arbitrators. That one's for you. Garland versus Cargill. So the National Firearms Act of 1934 empowers the ATF, the Bureau of Alcohol, Tobacco, and Firearms, to regulate machine guns. And so a machine gun is defined as any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. The term shall also include the frame or receiver of any such weapon, any part designed and intended solely and exclusively, or combination of parts designed and intended for use in converting a weapon into a machine gun, and any combination of parts from which a machine gun can be assembled, if such parts are in the possession or under the control of a person. So what ended up happening is that in 2017 and 2018, there were back-to-back mass shootings where bump stocks were used by the gunman. And so the ATF began a period of public comment in which they solicited the public to give them suggestions on should bump stocks be considered machine guns. And basically, after the public comment period ended, the ATF said, we're going to consider bump stocks machine guns, and we're going to begin regulating bump stocks. And so the respondent Cargill owned two bump stocks, which he surrendered to the ATF, and then on the very same day, he sued the ATF based on the idea that the National Firearms Act in its current form didn't empower the ATF to regulate bump stocks, and that if the ATF wanted that power, it would have to get it through an express grant by Congress. So can the ATF regulate bump stocks as machine guns under the National Firearms Act? The Supreme Court, in a 6-3 opinion, says no, it cannot. So the majority opinion, written by Clarence Thomas, says that the ATF cannot regulate bump stocks as machine guns because a machine gun is defined in the statute as something that allows you to shoot more than one bullet with a single function of the trigger. And so we get to the question of what is a function of the trigger. And the statute defines a function of the trigger to be pulling the trigger, but also any analogous motion. And what happened is the ATF conceded that the mechanism of a bump stock could be considered an analogous motion to pulling the trigger. Clarence Thomas also expressed some concern in his opinion that allowing the ATF to regulate guns which could bump fire would give them permission to also regulate semi-automatic rifles as machine guns, because semi-automatic rifles can bump fire just naturally without a bump stock being on them. It happens not all the time, but it does happen, and so Clarence Thomas is worried that because it does happen. If the ATF has the power to regulate bump firing as an act of a machine gun or a machine gun, then it would give them the power to regulate semi-automatic rifles as machine guns. The other argument that's pretty lethal to the ATF is that prior to its notice and comment rulemaking that happened in 2017 and 2018, it had on numerous occasions declined to regulate bump stocks as machine guns. So this can be like a big hurdle for agencies to clear when they try to move into what we call a new regulatory field. If they've declined to exercise the authority to regulate something in the past, then it's going to be hard for them to suddenly switch gears and say, actually, we think we're going to be regulating that now. And the case we're going to be looking at for that is FDA versus Brown and Williamson. In the first half of the 1900s, the FDA declined to regulate tobacco as a drug. But by the end of the 1900s, of course, a new body of research had been released showing the addictive capabilities and the narcotic capabilities of tobacco. And so the FDA says, well, actually, we are going to regulate this as a drug. And the Supreme Court in that case said, no, you can't, because you declined in the past to regulate it as a drug. So it would be contrary to the understanding of your authority if you were to suddenly be able to regulate it again. So Justice Alito did write a concurrence in which he emphasized that if the ATF could theoretically regulate bump stocks as machine guns, it just needs some express permission from Congress. An amendment to the National Firearms Act, for example, saying that we're explicitly giving the ATF this power to regulate bump stocks as machine guns. Justice Sotomayor wrote a dissenting opinion authored by Justice Kagan and Jackson, in which she said that the majority's opinion here sort of goes against what Congress intended. Congress, in passing the NFA, wanted to deter people from owning guns that would lead to a higher death toll, and bump stocks are a modification that have been facilitating higher death tolls in these shootings. And so she says by not allowing the ATF to regulate that as machine guns, you're basically defying Congress's intent, or you're going against Congress's intent. Okay, FBI versus Fikre, or Fikre. I don't know how to pronounce that last name, but I apologize if I get it wrong. Basically, the respondent Fikre is an Eritrean American, and in 2010 he was placed on the FBI's no-fly list because he was associated with a mosque in Portland, Oregon that the FBI had their eyes on for a while. The FBI approached Fikre and offered to take him off the no-fly list if he became an informant for them. He declined the offer and said that after that he was imprisoned and tortured in the UAE at the request of the FBI until he fled to Sweden seeking asylum. He later sued the FBI for violating his Fifth Amendment rights. While the action was pending in court, the FBI took him off the no-fly list and then moved to dismiss for mootness. So mootness is like a doctrine of justiciability, they call it. If the point of the case no longer matters, then it's considered moot. So if you have two parties who sue each other and then the court finds for the defendant, the plaintiff appeals, but then during the appellate process the parties settle, the issue becomes moot because they settled. There's no issue anymore. There are some exceptions to mootness. We see that with capable of repetition yet evading review is an exception to mootness. This happened a lot of times with the abortion cases before Dobbs came out, basically, because the idea is that the pregnancy period is only 9 months, and for an abortion case to make its way through the court, it will take longer than 9 months. So by the time it will be decided by the court, the baby will be born, and theoretically the issue would be moot. But the court said it's not moot because it's capable of repetition, right? More people are going to get pregnant and be seeking abortions, but it will evade review every time because it will just take too long to get through the courts. So instead of dismissing those cases for mootness, they say we're going to take them because they're capable of repetition yet evading review. Another exception to mootness is called voluntary cessation. That's sort of like what we have here with the FBI, where Fikre sues the FBI because he's still on their no-fly list for really no reason. And the FBI says, oh yeah, we'll take you off the no-fly list for sure. And then they say, well, there's no issue anymore because we took him off the no-fly list. Well, there's no guarantee that if Fikre drops the suit or if the suit gets dismissed for mootness, the FBI could still put him on the no-fly list after. So this voluntary cessation, the idea that you're voluntarily stopping the offending activity just for the suit to be dropped, and then you're going to resume that offending activity, that's what courts try to avoid, and so that's one of the exceptions to mootness. And so voluntary cessation is exactly what came into play here. The FBI took him off the no-fly list. The district court dismissed for mootness. Then this dismissal was appealed to the Ninth Circuit, which reversed the dismissal and said, because of voluntary cessation, we're going to allow this case to proceed. The idea is that there's no way to tell whether the conduct that initially got Fikre on the no-fly list is no longer going to be looked at when the FBI is deciding to put him back on the no-fly list type of thing. The FBI never specified, first of all, what conduct got Fikre on the no-fly list in the first place, and they also didn't specify that that this conduct, if it was repeated in the future, if it would land him on the no-fly list again. So the dismissal was reversed and the case was remanded back down to district court, and their FBI agent filed a declaration. The declaration basically was this promise, I guess, that we're not going to put Fikre back on the no-fly list, and so the district court dismissed the case for mootness again. The Ninth Circuit again reversed, and this time the reason that the Ninth Circuit reversed is that there was no change in the FBI policy. So if the FBI is not changing its policy on what conduct can get you on the no-fly list, then it doesn't really matter this declaration of the FBI agent, because that conduct could still get you on the no-fly list. So this gets appealed to the Supreme Court, and the question before the court is whether Fikre's case is moot because of the FBI agent's declaration, or is it still alive because there is no change in the FBI policy. And Justice Gorsuch authored the unanimous opinion of the court, which basically said that Fikre's case was not moot because in the FBI agent's declaration, he never specified what conduct got Fikre on the no-fly list in the first place, and there was no change in policies, so we don't know that that same conduct won't get Fikre on the no-fly list in the future. And Justice Alito did write a concurring opinion, joined by Justice Kavanaugh, just to make a clarifying point that the government doesn't need to disclose information that could be a threat to national security or compromise national security in order to prove mootness. Next, Harrow versus Department of Defense. The petitioner Harrow is an employee of the Department of Defense who was furloughed in 2013 actually. He appealed the furlough decision to the Merit Systems Protection Board, and the MSPB took 5 years to make a decision in that case. During that 5 years, Harrow changed his email address, and so 5 years later, the MSPB says, affirms the decision to furlough, so they said you were properly furloughed, but that notification goes to his old email address, and in this notification is a little note that says you have 60 days to file an appeal of this decision, and of course it goes to his old email, so he's not going to see it. So 60 days pass. He logs into his old email. He sees this. He sees the notification from the MSPB. He files an extension for time to appeal, which the MSPB denies because of lack of jurisdiction, because the 60 days have expired. And the Court of Appeals for the Federal Circuit affirms. They said that this 60-day requirement is jurisdictional, so it's not subject to equitable tolling. And equitable tolling just means that time limits can sometimes be stalled if certain things happen. A lot of deadlines, deadlines or expiration dates were told during the pandemic because so much chaos was going on and nobody knew what was going to happen next. So there was a lot of deadline extensions and tolling and things like that. So that's like a contemporary example of tolling. So the question is whether the 60-day deadline is a jurisdictional requirement, not subject to tolling, or if it is subject to tolling. Justice Kagan authored the unanimous opinion of the court, which said it's not a jurisdictional requirement, so it is subject to tolling. And she basically just looked at the language of the statute and the context it was passed in to say that it's a procedural requirement and not a jurisdictional one. Okay, so next up we have Moyle versus United States. So in 2020, Idaho passed a law which banned abortions in most cases, but this law would only go into effect if Roe versus Wade got overturned. And of course in 2022, with the Dobbs versus Jackson Women's Health Organization opinion, Roe versus Wade did get overturned, and so this law went into effect. The Biden administration sued Idaho on the grounds that the state law was preempted by the federal law, which was the Emergency Medical Treatment and Labor Act, which said that for any hospital receiving Medicare funding, they have to provide stabilizing treatment in emergency conditions or emergency situations. And the Biden administration argued that even though the Idaho law did allow an exception for cases when the mother's life was at risk or in cases of rape or incest, the Biden administration still argued that there were medical emergencies for abortion that were not in those three exceptions. And so they said that the federal law, EMTALA, preempts the state law. Basically what preemption is you have the supremacy clause in the Constitution, which says that the federal law is the supreme law of the land. So if there's a state law in conflict with the federal law, then the federal law basically trumps the state law. And so that's what's going on here. Now the interesting thing is that on June 26th, the Supreme Court accidentally published a rough draft of its opinion for this case on its website very briefly, and then it took it down. And then on June 27th, a day later, it published the actual opinion for this case, which was not like the draft, and it was a one-sentence per curiam dismissal for improvident grant. And so what that is, a dismissal for improvident grant, is when when an appellate court decides to hear a case, and then some point after they decide to hear it, they say, oh, maybe we shouldn't have heard this case. So they say, oh, we messed up in saying that we're going to hear this case. We actually don't want to hear this case. So it's an improvident or an improper grant is the way you can think about it. So yeah, that's basically what happened. They said we kind of messed up deciding to take on this case, and then it was a one-sentence per curiam opinion. A per curiam is like an anonymous opinion. You don't know who signed it. So a dig, by the way, is not unheard of at the Supreme Court level, but it's definitely uncommon. Even crazier is that below this unsigned per curiam dig, you have all the justices basically getting into a scrum of concurrences and dissents. So Justice Kagan wrote a concurrence joined by Justice Sotomayor and Justice Jackson only as to Part 2. Justice Jackson only joined Part 2 of Justice Kagan's concurrence. Justice Kagan agrees with the dig, but she says that the Idaho law is preempted because there are situations not covered by the exceptions in the Idaho law. Like, for example, sometimes a pregnancy can cause a loss of fertility in the future. And so in that situation, a woman might want to receive an abortion, but under the Idaho law, she wouldn't be able to. And so Kagan says EMTALA preempts that law here. In that situation, the hospital would be required to provide that stabilizing treatment. Justice Barrett wrote a concurrence joined by Justices Kavanaugh and Gorsuch, where she said that new developments in the case and some concessions that Idaho had made during oral arguments made it clear that it wasn't necessary to decide this case anymore. Because Idaho made a lot of concessions at its oral arguments. Basically, any exception that the Biden administration offered, that they said this is not covered under the Idaho law basically said, oh yeah, we'll make an exception for that too. Who knows if they would have made an exception for it in practice. Justice Jackson wrote a concurrence in part and a dissent in part. She concurred as to enjoining the Idaho law, so allowing emergency abortions to continue in Idaho, but she dissented as to the dig. She thinks that the court should have taken the case on the merits and decided it, and she would have decided it in favor of the United States government. So this case is really interesting to me because the majority that signed the per curiam basically avoided the question of the hour, right? This was a fairly important question, and the majority just kind of skirted around it in favor of this bizarre anonymous opinion. And then you just sort of have like a total mess going on below it with all sorts of concurrences and dissents and concurrences in part and dissents in part, and I'm going to join this opinion only as to this specific part. But yeah. If there were new developments or if Idaho made that many concessions during oral arguments, I guess I'm not too surprised at the dig. Okay, Chiaverini versus City of Napoleon, Ohio. So what do we have going on here? We have the petitioner, Chiaverini. He owns a jewelry store. He buys a ring from a thief for $45. The true owners of the ring end up finding out about this. They contact Chiaverini. They ask for the ring back. He doesn't want to give it back. He refuses. So they go to the police. The police come by the jewelry store on a couple different occasions to see what's up. They direct him to give the ring back, and he says, actually, I'm not going to give the ring back because I have a letter from the police department telling me to keep the ring as evidence. And he also, during this time, admits to the police officers that he's operating his jewelry store without a license. So, big mistake there, buddy. Don't talk to the police next time. Get a lawyer. His confession that he's operating without a license prompts a criminal investigation against him. The police end up bringing 3 charges against him: misdemeanor receipt of stolen property, misdemeanor dealing in precious metals without a license, and felony money laundering. So after bringing these 3 charges, the police then petition the municipal court to issue a warrant for his arrest. And basically, in order to get a warrant for somebody's arrest, you have to show that you have probable cause that they committed the crimes. So in this case, the police have to show that they have probable cause for all three of the crimes: the receipt of stolen property, the dealing in precious metals without a license, and the money laundering. So there's some issue as to whether or not they have probable cause for the money laundering, because their case for the money laundering is that Chiaverini knew that he was receiving a stolen ring. Where do they get this idea that he knew that the ring was stolen? Well, the police say that Chiaverini told them that he suspected the ring of being stolen all along. Chiaverini denies this, though.
His attorney, Michael Stahl, says the original police report, though, didn't match an updated one. Chiaverini said he wasn't aware the jewelry was stolen when he first bought it, but police changed the report a few weeks later to say he did know it was stolen when he bought it.
In the end, the judge ends up issuing an arrest warrant, and Chiaverini is arrested and detained for 3 days. So he's detained for 3 days. The charges are set for trial, but the prosecution fails to bring the case within the required time limit, so the charges end up getting dismissed. And after this, Chiaverini sues the police officers for malicious prosecution. And so malicious prosecution is just bringing charges against a person without justification. So he's saying the charge of money laundering specifically was brought without justification. He concedes that there was probable cause for the receipt of stolen property and for the dealing in precious metals without a license, but he says because there's some issue for the money laundering about whether or not he knew that the ring was stolen all along, he says there's no probable cause for this charge to have been brought, and that's malicious prosecution. The district court granted summary judgment in favor of the officers. Some of you might not know what summary judgment is. Basically, this is a procedural motion where one party motions for summary judgment, and if it's granted, then the outcome of the trial is in their favor. So the idea behind summary judgment is that, if you're the plaintiff and you motion for summary judgment, the idea is that the evidence is so strongly in favor of the plaintiff that any reasonable jury would have no choice but to decide for the plaintiff. And if you're the defendant and you motion for summary judgment, the idea is that the plaintiff's evidence is so weak that no reasonable jury could ever find for the plaintiff, and any reasonable jury would end up finding for the defendant. So then, if it gets granted, it would be in favor of the defendant in that case. So the officers motion for summary judgment on this malicious prosecution claim. They're saying the evidence for malicious prosecution here is so weak that any jury would not have any choice but to find for the officers, and the district court agrees with that, so they find for the officers. This gets appealed to the United States Court of Appeals for the Sixth Circuit, which affirms the decision of the lower court. The Sixth Circuit does not address the merits of the malicious prosecution claim. It instead just says, well, we have two charges where there was probable cause to support those charges, and as long as you have one charge supported by probable cause, all of the other charges are insulated from malicious prosecution claims. So the Sixth Circuit affirms the decision of the lower court, and this gets appealed to the Supreme Court. So the question here is, if you're a defendant and you're charged with committing multiple crimes, and at least one of the crimes is supported by probable cause, does that insulate or does that protect all the other claims or all the other charges from malicious prosecution claims, or can you still bring a malicious prosecution claim? In a 6-3 opinion written by Justice Kagan, the court concludes that one validly supported charge does not insulate other charges which may be invalidly supported. Now, the idea behind this is that if you're being unreasonably seized and unreasonably detained, this is a violation of your Fourth Amendment right? And so if you're being held validly on two charges but invalidly on one charge, that right is still being violated. Interestingly, though, while the case was pending in the Supreme Court, the officers actually switched positions to say the Sixth Circuit got it wrong, that one valid charge does not insulate all the other charges. And so you might be thinking, well, if the officers basically agree with the petitioner, then why doesn't this case get dismissed for mootness? And so the officers sort of find a subtle point to disagree on, which is that the officers are saying to prevail on a malicious prosecution claim, Chiaverini needs to show that the invalid charge was the charge that caused him to be unreasonably detained. So there's this issue of causation now. So now the Supreme Court is faced with answering this additional question of how do we determine the validity of an arrest warrant that's based on multiple charges where some of them are good or some of them are supported and some of them are not supported. How do we determine if the arrest warrant was validly issued in that case? Well, the majority doesn't give us an answer. They say that's a decision for a future court to make. We're just making this distinction here that one validly supported charge does not insulate all the other charges, and maybe in the future we're going to hear a case on the validity of the arrest warrant. And this is just because this only happened while the case was pending in the Supreme Court, so the parties didn't address the causation argument in their briefs or in their oral arguments. So it wouldn't really be appropriate for the court to address it here, having not been fully briefed on the situation. Clarence Thomas did write a dissenting opinion joined by Justice Alito. His dissent criticizes the majority for characterizing these malicious prosecution claims as unreasonable seizure claims. And to support this idea, he says malicious prosecution claims don't require an unreasonable seizure to have occurred, whereas unreasonable seizure claims do require an unreasonable seizure to have occurred. So because of this, they're two different things, is what he's saying. Justice Gorsuch also wrote a dissenting opinion saying something very similar to Justice Thomas. He said, a malicious prosecution claim is not the same thing as a unreasonable seizure claim, but in Justice Gorsuch's opinion, a malicious prosecution claim is more aptly sort of couched into the language of the 14th Amendment, rather than the Fourth Amendment. Okay, City of Grants Pass versus Johnson. This is a big one. This is one I was really excited for. This is infamously one of the most impactful Supreme Court decisions on people experiencing homelessness in a long time. And I just want to offer a disclaimer as well. I'm going to be saying the words people experiencing homelessness, or also for the sake of brevity, unhoused people. If it turns out in the future that these are not the most appropriate or most correct terms to be using, then I sincerely apologize for that. And just understand that I'm not using these terms to be offensive. I want to make sure that I'm approaching this situation giving as much humanity as possible to people experiencing homelessness, Because I know in previous court opinions or things like that, they will really use some harsh language to describe them. So I just wanted to make sure that there's an air of humanity when I talk about it. So how do we get to Grants Pass versus Johnson? Well, we need to go all the way back to Robinson versus California, which is a Supreme Court case that said that state and local governments can regulate conduct, but they can't regulate statuses. So in Robinson versus California, California had a law which made it illegal to be addicted to drugs in California. And the defendant in that case was stopped by police and they spotted needle marks in his arm. He was charged and convicted of being an addict in California, even though he testified that he had not used drugs in the state of California. He was just visiting California. And so in that case, the Supreme Court said state and local governments can regulate conduct. They can regulate the possession of narcotics, the possession of drugs, but they cannot regulate status, such as the status of being a drug addict. So then this creates the question of what is a status versus what is conduct. And the Supreme Court elaborated on that in Powell versus Texas. And in Powell, the court said you can regulate conduct, such as appearing drunk in public, but you can't regulate status, such as being an alcoholic. And that was the issue in Powell. But the problem with Powell is that it was a plurality opinion. So they couldn't get a majority. So that opinion is not binding. And so we have this question of what do we do when status and conduct are closely linked together? How do we separate what's status and what's conduct, and what are the regulatory bounds of each? And so status becomes linked to conduct. We see an example of status being linked to conduct when we think about people experiencing homelessness, right? Their conduct, things like sleeping outside or bathing in public, or starting a campfire to keep themselves warm. That's all conduct. Isn't it almost inextricably linked to their status of somebody who's experiencing homelessness? And so that's the question that the courts have been tasked with for a long time. And so one of the first big answers we get on this comes way back in 2000 in Joel versus City of Orlando. And in that case, you have a defendant who's experiencing homelessness, who is charged with or is convicted of sleeping in public. And I just want to say, by the way, a lot of times getting convicted of these crimes usually comes with a monetary fine or a prison sentence. So it's not necessarily conducive to letting these people sort of get back on their feet, because now they have to pay a monetary fine. They have to spend some time in jail. If they can't pay the monetary fine, which they can't do most of the times because they can't even afford housing, then that in itself can come with some problems. So in Joel versus City of Orlando, he's convicted of sleeping in public. He challenges it as being cruel and unusual, as being a regulation of his status. And that case only went up to the Court of Appeals for the 11th Circuit. So it didn't make it to the Supreme Court, but the 11th Circuit basically says in the city that the defendant is in, which was Orlando, there was evidence that some homeless shelters nearby had vacancies. And so the 11th Circuit says, well, if there's vacancies and you're experiencing homelessness, then you can't be sleeping outside. Or local governments have the power to sort of convict you of sleeping outside if there's vacancies. And so Joel kind of creates this distinction between involuntary conduct and voluntary conduct, right? If the 11th Circuit is basically reasoning that if there's vacancies in homeless shelters nearby, then your decision to sleep outside, your conduct is voluntary, and that can be regulated. If there's no vacancies in the homeless shelters nearby, then your decision to sleep outside is involuntary. You have no other choice but to do that, and that cannot be regulated. You cannot be convicted in that case. That's what the Joel opinion stands for. It takes 19 years for this theory proposed by the Joel court to get tested. In 2019, there's a case called Martin versus City of Boise, and it's a very similar ordinance, very similar circumstances, except in Martin, there's the additional caveat that there's not only can you not sleep in public, but you can't have things like bedding or pillows in public. That was another law at issue in Martin. And also, the facts of Martin were a little bit different in that there was evidence that the homeless shelters nearby were all full. And so the court in Martin says, the homeless shelters nearby were full. The defendant's conduct was involuntary. It can't be regulated. Convicting of him of sleeping in public would violate his Eighth Amendment rights. The problem with Martin, though, is that once the Ninth Circuit makes that decision, which that was the Ninth Circuit, by the way, Joel was the 11th Circuit, this was the Ninth Circuit. Once the Ninth Circuit makes that decision, it remands the case back down to lower court and the parties settle. So that opinion in Martin is no longer binding. And so that's where we get to Johnson versus Grants Pass. So Grants Pass is a city in Oregon. It has the exact same anti-camping ordinances, or sometimes they're called anti-homeless ordinances, that were at issue in Martin. And so the court in Grants Pass adopts the reasoning in Martin. They say if the shelters are full, then your decision to sleep outside is involuntary and you can't be convicted of sleeping in public. They also say, using some of the reasoning in Martin, that if you have the right to sleep in public, then you have the right to those things which can facilitate sleep, such as bedding or pillows. So the upshot of this is that if there's no vacancies at the nearby homeless shelters, if your conduct is involuntary, I'll put it like that. If your conduct is involuntary, then you have the right to sleep in public, and you also have the right to those items which can facilitate sleeping in public, such as bedding and pillows. So the question before the Supreme Court is whether these anti-camping or anti-homelessness ordinances, which criminalize things like sleeping in public or having bedding in public or starting campfires in public, whether they violate the Eighth Amendment's prohibition on cruel and unusual punishment, if that sleeping in public or bathing in public or what have you is as a result of nearby shelters being full. Is it a violation of the Eighth Amendment in light of that? Well, the Supreme Court, in a 6-3 opinion authored by Justice Gorsuch, says no, it does not violate the Eighth Amendment's prohibition on cruel and unusual punishment for state and local governments to criminalize things like sleeping or bathing or starting fires in public or having bedding in public. Even if there are no other sort of legal alternative means for getting shelter. The majority starts by saying that even though Robinson stands for the proposition that statuses cannot be criminalized, the Grants Pass ordinances are neutrally applied here because they apply to everybody, meaning that everybody is prohibited from sleeping in public, everybody is prohibited from bathing in public, everybody is prohibited from having bedding in public. And frankly, this argument seems extremely disingenuous to me and sort of purposely hiding the ball almost. It's very reminiscent of the Anatole France quote, which is like, the majestic equality of the law is that rich and poor alike are forbidden from begging in the streets or stealing or sleeping under bridges or things like that. And the Anatole France quote is satirical, and here the court is almost saying that sincerely, and it's like, yeah, it's neutrally applied. Yeah, nobody is allowed to sleep in public or nobody is allowed to having bedding in public, but obviously there's a group that's disproportionately more likely to involuntarily sleep in public or be forced to sleep in public. And to sort of purposely ignore that and put on the blinders felt very disingenuous to me. The majority also said that the Eighth Amendment's ban on cruel and unusual punishment is primarily focused on post-conviction punishments. To be honest, I did not really understand the substance of this argument here because this is a post-conviction punishment, right? After you get convicted of sleeping in public, you have the punishment of a prison sentence or the punishment of an additional fine. So I'm not really sure what Justice Gorsuch was getting at here when he was trying to specify that the Eighth Amendment, that cruel and unusual punishment is like primarily targeting post-conviction punishment because this is post-conviction punishment. The majority also pointed to Powell versus Texas, which upheld a public intoxication law. And Justice Gorsuch points out that in that case, status is closely linked with conduct there, mainly like the status of being alcoholic being closely linked with the conduct of appearing intoxicated in public. And he said, if that public intoxication ordinance is all right, then the anti-camping or anti-homeless ordinances in Grants Pass are all right. And I think the dissent has a really good criticism of this, so I will save my comments for when I talk about the dissent. Justice Gorsuch also tries to reassure those experiencing homelessness. He says, if you're experiencing homelessness and you're faced with a prison sentence or fine, don't worry. You can always just raise a necessity defense at trial. And again, the dissent has a really good counter to this, which I really liked. Finally, Justice Gorsuch says that the courts are not the right venue to be deciding what this country's policies on homelessness should be, and that's something that's better left up to the states. You didn't go far enough. We need to overturn Robinson versus California. States and local governments should be able to criminalize statuses. States should be able to criminalize being addicted to drugs or being an alcoholic. And it's like, yeah, that's a really good idea, Clarence Thomas. We should be able to criminalize statuses. You know, for example, you're a judge. You're a pretty wealthy guy. You know, maybe we should criminalize being wealthy, right, Thomas? You wouldn't have a problem with that, right? Because it's just a status, and we should be able to criminalize statuses, right, Clarence? I mean, we should overturn Robinson and we should make it illegal to be wealthy, right, Clarence? Is that what you think? Or how about this? You're a federal judge, right? What if a state makes it a crime to be a federal judge within the state? Is that okay, Thomas? Because it's just a status, right? And listen, Robinson just needs to be overturned. Listen, the court didn't go far enough. We should be able to criminalize statuses, guys. So yeah, let's make it illegal to be wealthy. Let's make it a crime to be a federal judge. And you know what? I see those scraggly little white hairs on the top of your head. Let's make it illegal to have white hair, Clarence Thomas. What do you think about that? Because it's just the status of having white hair. We should be able to criminalize it because we need to overturn Robinson, Clarence. You're so right. It's like we're begging you, Clarence. We're begging you here. Please think about the implications of the things you're writing for like more than 2 seconds. I know it's hard. I know you want to keep partying on Harlan Crow's yacht, but like seriously, just ignore the party for just a second. Go out onto the deck of that yacht, look at those beautiful ocean waters, and just think about the stupid shit you've been writing recently and think about its implications. Please, we're begging you. God. Justice Sotomayor also did write a dissent joined by Justices Kagan and Jackson, which I thought was very on point. The dissent, which is what I was sort of getting at earlier, says that the neutrality of these ordinances is irrelevant because it's disproportionately going to impact those experiencing homelessness more than those who aren't. The dissent also criticizes the majority's use of Powell, the idea being that the status linked to the conduct in Powell is a lot more ambiguous than what we have here, because in order to get status that's linked to conduct in Powell, what you have to have is somebody who's an alcoholic and they drink themselves into intoxication, and they appear in public. You have to have those three things. What Justice Sotomayor said was that it isn't always the case that somebody who's an alcoholic is going to definitively drink themselves into drunkenness and then appear in public. You know, they may feel an addiction that compels them to drink until they're drunk, but they can still stay at home or not appear in public, is what she's saying. Whereas in Grants Pass, we have people who are forced involuntarily, they have no choice but to sleep outside because of their status as somebody who's experiencing homelessness. So she says, in this case, we really truly have somebody whose status is inextricably linked to their conduct. Whereas in Powell, it's a lot more ambiguous whether that's the case. She also makes a very pragmatic argument that allowing states and local governments to criminalize homelessness would lead to a lot of people who are experiencing homelessness to develop a criminal record if they don't already have one. And she said that's going to hurt their employment opportunities in the future, and it's going to make it harder for them to get out of this cycle that they're in. About the necessity defense, the dissent also takes a pragmatic approach, which I really appreciated. They said that if you're experiencing homelessness and you're in an area where you're being cited and picked up by police and these fines are being imposed by you and there's the threat of a criminal sentence, you're not going to take the time to engage in costly years-long litigation just so that you can raise a necessity defense. What's more likely is that you're just going to move to a different area. So she said this idea that don't worry, you can just raise a necessity defense is not really going to work in practice. So where do we go from here? The dissent identifies 4 different ways in which the Grants Pass ordinances or similar ordinances can be challenged. The first is that specifically in Grants Pass, Oregon has a state law which forbids police from arresting people for sleeping. So the dissent says there is a preemption claim that may be successful here. The dissent also says that similar ordinances or ordinances that impose fines can be challenged under the excessive fines clause of the 8th Amendment. She also says that the ordinances can be challenged for violating due process, and they can also make the challenge that because they're being forced as a result of these fines to move away from their communities, this is essentially the equivalent of denaturalization, and denaturalization as a punishment was ruled to be violative of the 8th Amendment in Trope v. Duels. Okay, Murray versus UBS Securities, LLC. So this case starts in 2011 when the petitioner is hired by the respondent, and he's hired as a strategist for a mortgage-backed security business. SEC regulations required that any report prepared by the petitioner, Murray, had to be disclosed as an independent report that reflected only the petitioner's views. However, the petitioner reported to his supervisors that he was being hired by higher-ups within the companies to skew his research. And so his supervisor, as a result, did absolutely nothing, and he was fired in 2012. In 2014, Murray sued UBS Securities, saying that his firing was retaliation for him firing the conduct of his higher-ups. And so this makes it all the way up to the Supreme Court, where the question is whether the anti-retaliation provision of the Sarbanes-Oxley Act requires the plaintiff to prove that his employers had retaliatory intent when firing him. Justice Sotomayor authored the unanimous opinion of the court, which says that a plaintiff only needs to show that their conduct was a contributing factor to their firing, and they don't need to show a retaliatory intent on the part of their employer. And in fact, the burden rests on the employer to prove that they would have fired the employee anyways, with or without the whistleblowing. Justice Alito did write a concurrence joined by Justice Barrett, but honestly, I think that the distinction he makes in his concurrence is so minor and splitting hairs that it's not worth getting into. Okay, Loper Bright Enterprises versus Raimondo, the big one, the one that overruled Chevron. This is probably one that's been in the news recently. It's going to keep being in the news. It's going to be in a lot of the textbooks in the future. This was a really massive decision. The 1976 Magnuson-Stevenson Fishery Conservation and Management Act empowered the National Marine Fisheries Services, which is an agency within the Department of Commerce, to require fishing boats to carry monitors on board to prevent overfishing. In 2020, due to budget cuts, the NFMS required that the industries, the people participating in the fishing industry, would have to pay for their own monitors, whereas I guess before the NFMS was sort of subsidizing this and placing these monitors on board at their own cost. So the petitioner, Loper Bright Enterprises, is a New Jersey-based fishing company, and they operate specifically a herring fishery. And so the MSA doesn't specifically authorize the NFMS to require monitors on boats in herring fisheries, but the NFMS has interpreted the statute to allow them to require monitors on boats in herring fisheries. So Loper Bright sues the NFMS in the United States District Court for the District of Columbia, alleging that the MSA does not give the NFMS the authority to require industry-funded monitors on its boats in herring fisheries, specifically herring fisheries. So what does the district court do? They applied the Chevron two-step. And what is the Chevron two-step? Well, it's a two-part test that comes from an old Supreme Court case called Chevron versus Natural Resource Defense Council. The details of that case are sort of irrelevant here, but the idea is just that Congress grants agencies broad and oftentimes ambiguous powers because agencies are made up of fields of experts in whatever the field the agency is about. So the NFMS is probably filled with wildlife biologists and marine biologists, people who know about fishing, people who are experts in fishing, people who are experts in overfishing and population control and ecological conservation and things like that. So Congress gives these agencies broad swaths of authority because Congress says, we're not the experts, you guys in the agency are, so we're going to give you all this authority, and then from there you use your expertise to sort of narrow it down and see, in your expert opinions, what should be regulated. So the outcome of Chevron, this two-step test, is that whenever somebody is challenging an agency's interpretation of a congressional statute which gives them authority to do something, the court is going to look at the statute itself, and it's going to look at the intent of Congress in passing the statute, and it's going to try to see if there's ambiguity in the congressional intent in passing the statute. That's step one of the Chevron test. If the congressional intent is unambiguous, if it's clear, then the courts are going to defer to the congressional intent. And if the agency interpreted the statute in contradiction to the congressional intent, then that interpretation is likely going to be impermissible, and that rule is going to be vacated. If the congressional intent is ambiguous, then we move to step two of the Chevron two-step, which guides the courts into basically deferring to the agency's interpretation of the statute. And it's a very broad deference. Almost always under Chevron, they're going to give deference to the agency. Again, and it's for similar reasoning, because the courts are not made up of experts in whatever field that the agency is regulating, right? The agency is made up of those experts. So the courts say, we're going to give deference to the agency as long as it's a reasonable interpretation of the statute. You guys can regulate that, or you guys can interpret it the way that you want it to. Notably, Chevron has been pretty much under attack since its inception. Most of the criticisms are coming from conservatives who think that it gives the executive branch way too much power because these are executive agencies, so they're part of the executive branch. They think that the judiciary is basically needlessly capitulating to the executive branch, and they think it violates the separation of powers. And so what we've seen very recently, probably within the last decade or so, is the Roberts Court sort of slowly eroding and chipping away at the Chevron doctrine, is what it's called. Chevron doctrine, Chevron deference. You'll hear it interchangeably. This started when this started when the court began to retroactively look at FDA versus Brown and Williamson as not a Chevron case. So FDA versus Brown and Williamson, which is a case I believe I've talked about so far, but I don't know because I'm recording these clips out of order. But I mentioned FDA versus Brown and Williamson in one of these cases. FDA was originally decided sort of in the same context as Chevron. Within the past decade or so, the court has begun to retroactively sort of wipe away this Chevron context from FDA and instead call it more of a major questions case. And so we saw the emergence of this major questions doctrine really coming to the forefront in West Virginia versus EPA and in Biden versus Nebraska more recently. Many people were waiting with bated breath to see if this case would be the final nail in Chevron's coffin, and it did turn out to be that way. That's the Chevron two-step. The district court used the Chevron two-step. It found that the MSA was not ambiguous and that that Congress had clearly given its intent to allow the NFMS to require monitors on herring fishery boats. The case gets appealed to the Court of Appeals for the D.C. Circuit, which again uses the Chevron test, but this time it says the statute is ambiguous, but it still says that the agency's interpretation of it is reasonable. So the NFMS's rule to require industry-funded monitors on board herring fishery boats stands. And then this gets appealed to the Supreme Court. And it gets appealed to the Supreme Court. The Supreme Court decides to hear it only on the question of whether or not to overrule Chevron outright. So the question before the court is just whether or not to overrule Chevron. In a 6-3 opinion authored by Chief Justice John Roberts, the court does decide to overrule Chevron. Roberts did so because he said it's the job of the court to determine if a law means what an agency says it means, as opposed to just giving blanket deference to agencies, which is what was happening under Chevron. Roberts also said that technical expertise can still come into the courts in the form of expert testimony or amicus briefs, but there is sort of like I have sort of a pragmatic concern with this, similar to what the dissent said in Grants Pass over whether or not we're going to see defendants use the necessity defense in practice because they're experiencing homelessness. They're more likely to just move out of the area. Similarly, here I wonder if we're going to see this expert testimony or these amicus briefs really be effective in the future, or if they'll sort of fall on the deaf ears of the judiciary. Of course, this decision is so fresh, though, that there's no way that I can know that at this point. Roberts also complained that Chevron had become increasingly more difficult to work with over the years, and he said that in the last couple of years that it had just become unworkable. And what I say to that is, one of your justices can't figure out how to fly a flag the right way up, and the other justice is constantly daydreaming about life in the 1820s. Of course they're having trouble using Chevron. Roberts also attempted to soften the blow by saying that deference can still be given to agencies. It would just be under Skidmore deference. Skidmore versus Swift and Company is a 1944 Supreme Court case that established a case-by-case persuasiveness test for determining if deference should be given to agencies. So we go back to Skidmore deference, then what happens is the agency will just have to make a case and try to make a persuasive argument as to why its expertise should be deferred to, and the courts are going to decide it on a case-by-case basis. And the last time we really had courts deciding stuff pretty much the only times that we've had courts deciding stuff on a case-by-case basis is the death penalty and obscenity. And those are like two of sort of the messiest areas of Supreme Court jurisprudence because they just go back and forth, depending on sort of the political leanings of the justices on the courts. So I fear that Skidmore deference, if we go to Skidmore deference, then agency interpretation is going to fall in sort of the same category as obscenity law or death penalty law, where there really is no rhyme or reason. I mean, a lot of Supreme Court cases seem to avoid rhyme or reason, but these areas especially so, where you're more so arguing to the justices' personalities as opposed to any sort of substantive point of law. Justice Thomas wrote a concurrence in which he agreed with the outcome and emphasized that Chevron was inconsistent with separation of powers. Justice Gorsuch also wrote a concurrence in which he said that Chevron deference forced the courts to be biased in favor of the government. Again, this was like another sort of disingenuous, it felt disingenuous on the part of Gorsuch, acting as though the courts have always been like a totally unbiased body. And I mean, the first thing I went to is like strict scrutiny, right? If you pass a law that discriminates against certain protected classes like race or religion, then you have to pass strict scrutiny. And a court reviewing a claim for strict scrutiny is going to be highly skeptical of the government's claim that this is a legitimate government interest, a compelling government interest, narrowly tailored, right? From the outset, their their mindset is that this is going to be unconstitutional, right? So I don't know, for Gorsuch to suggest that it's just totally unheard of for reviewing courts to have any sort of biases that are established by law, I mean, and not like personal biases, for him to say that felt a little bit disingenuous and sort of ignoring a whole body of law, really. Justice Kagan wrote a dissent joined by Justices Sotomayor and Jackson, in which she expressed concern that taking away this broad deference to agencies is going to create disruption and hurt their ability to regulate some of the more pressing issues of our time, such as climate change. Justice Kagan did also have a pretty lethal quote, which I want to read here. She said, "If the majority thinks that the same justices who argue today about where ambiguity resides are not going to argue tomorrow about what respect requires, I fear it will be gravely disappointed." You know what? That's like a scathing dissent. Okay, McElrath versus Georgia. So in 2017, petitioner McElrath was found guilty but mentally ill for felony murder, but not guilty by insanity as to malice murder for the killing of his mother. The Georgia Supreme Court eventually reviewed it, vacated the conviction, and ordered a new trial. McElrath challenged his new trial on the double jeopardy clause, saying that he'd already been found guilty but mentally ill for felony murder. McElrath challenged the new trial as a violation of his double jeopardy clause. He said he was already found not guilty by reason of insanity, and so that trying him again would violate his double jeopardy rights. So the unanimous opinion authored by Justice Jackson says, perhaps unsurprisingly, that subjecting a criminal defendant to a new trial after they'd already been found not guilty is a violation of their double jeopardy clause. It's a violation of their double jeopardy rights. And basically, it just comes down to the legal theory that a verdict of not guilty is sort of a final and irreversible announcement that the prosecution had failed to show that the defendant had committed the crime which they were accused of beyond a reasonable doubt, right? And so a verdict of not guilty by reason of insanity is still a not guilty verdict, and so it still carries with that. It still carries with it that legal theory that it's a final, irreversible announcement. The prosecution failed to bring the evidence to show that the defendant committed malice murder. I think in this case he was found not guilty of. Failed to commit malice murder beyond a reasonable doubt. Justice Alito did author a concurring opinion in which he emphasized that the court is not taking a stance on whether two verdicts that are inconsistent with each other is still considered an acquittal, right? Because for the murder of his mother, he was found both, in a sense, guilty but mentally ill, and then also not guilty by reason of insanity. And so there's some question there as to whether these two conflicting verdicts, because how can you be guilty and not guilty for the same conduct? There's some question here as to whether this is really an acquittal or really is really an acquittal, and Justice Alito says the court is not taking a stance on that right now. Okay, Diaz versus United States. In 2020, Delilah Diaz was driving back to America after having a little trip in Mexico. She was going through a border patrol checkpoint thing. And while she was there, the Border Patrol agents found 28 kilograms of meth in the paneling of her car, I believe. So they arrested her and charged her with importation of methamphetamine, which requires that the defendant knowingly transport methamphetamine into the United States. And so basically her defense is that the knowledge requirement that she knowingly transport meth into the United States, that's not satisfied because she didn't know she had meth in the paneling of her car. Because she says that she took the trip to Mexico with her daughter and her daughter's boyfriend, whose name is Jesse. And Jesse let her use his car to drive back and said he was just going to pick it up once he gets back to the United States. So Delilah says, I didn't know there was meth in the car because I was borrowing Jesse's car. So you can't prove that I had knowledge that I was transporting meth into the United States. So in response, the United States wants to get an expert witness who can testify as to the mental state of most drug couriers, and say whether or not they have knowledge that they're carrying drugs into the United States. And Diaz before trial seeks to exclude this witness from testifying, basically saying that this sort of testimony is prohibited by the Federal Rules of Evidence, Rule 704B, which prohibits an expert from testifying as to their opinion of the mental state of the defendant at the time of the offense. So she's worried that the expert witness is going to testify, Diaz is a drug courier, and in my opinion, drug couriers have this mental state, have the state of knowledge when they are transporting drugs. Therefore, in my opinion, Diaz knew she was transporting drugs into the United States. That's what she's afraid of. So, over her counsel's objections, the court decides to go ahead and let the expert witness testify. And he testifies as to the mental state of most drug couriers. So he says most drug couriers know they're transporting drugs into the United States. And Diaz ends up getting convicted. She appeals her conviction and makes it all the way to the Supreme Court. So the question before the court is whether expert testimony as to the expert's own opinion of the mental state of most people or most people in a certain group is allowable under 704B. So in a 6-3 opinion written by Justice Thomas, he says that Rule 70B does not forbid this expert from testifying as to his opinion of the mental state of most drug couriers. And the reasoning for that is that Thomas concludes that testifying as to the mental state of most drug couriers is not the same as testifying as to your opinion of the drug state, the mental status of the defendant in particular, which would not be allowed. Justice Jackson did write a concurrence in which she said that neither the prosecution nor the defense can offer testimony or can offer a witness who can testify as to their opinion of the mental status of the defendant, but she emphasizes that both the prosecution and the defense can offer expert testimony as to what the expert's personal opinion of what the likelihood that particular defendant's mental status was. And so what that means is that you can't have testimony where the expert goes, in my opinion, the defendant had knowledge that they trafficked drugs into the United States. But you can have an opinion, you can have an expert testify and say, in my opinion, I think that it was somewhat likely that the defendant had knowledge that they were trafficking drugs into the United States. That's Justice Jackson's opinion. Justice Gorsuch wrote a dissent joined by Justices Kagan and Sotomayor, and the dissent basically criticizes the majority for giving prosecutors a new tool to basically circumvent 704B. So we can't get anybody to testify about what they think the defendant's mental status is, but we can get somebody to testify as to their opinion of what the mental status of most people like defendant are, and then all we have to do is look to the jury and say, all you have to do is find that the defendant is just like most people, right? So an example of that would be like, the witness can't say, in my opinion, the defendant had knowledge of that they were trafficking drugs into the United States, but the expert can say, in my opinion, most drug couriers know that they're trafficking drugs into the United States. And then the prosecution just needs to look at the jury and say, members of the jury, we just need you to find that the defendant is like most people or like most drug couriers, and that's it. All right, Thornell versus Jones. So in 1992, the respondent and Robert Weaver got into an altercation after a day of drinking and smoking meth. The altercation ended when Jones fatally struck Weaver in the head with a baseball bat, and Jones also attacked Weaver's grandmother and strangled Weaver's 7-year-old daughter. At trial, Jones was represented by a public defender who is inexperienced with capital cases, and this public defender received limited funding for expert witnesses. Jones was convicted, and his sentencing hearing included testimony regarding child abuse that occurred during his childhood, as well as his history of drug abuse and testimony from a psychologist regarding how all of these experiences could have made Jones a more violent person. In the end, Jones was convicted and sentenced to death. Jones challenged his conviction on the grounds that he received ineffective assistance of counsel, mainly because he believed that there was some mitigating evidence that his trial counsel failed to present to the court. So the question before the Supreme Court now is, how should courts analyze a defendant's claim that his counsel's failure to present mitigating evidence constituted ineffective assistance of counsel and prejudiced their jury? Well, in a 6-3 opinion authored by Justice Alito, the court says that other courts have to weigh all the aggravating and mitigating factors, which is typical of most death penalty cases nowadays, and then also weigh if the additional mitigating factors, which the defendant says that weren't initially presented, would be reasonably likely to avoid a death sentence. And in weighing aggravating and mitigating factors, Alito says that courts can take a look or can make a credibility determination of different expert witnesses. In this specific case, Alito says that the additional mitigating evidence would not have outweighed the aggravating evidence, mainly consisting of attacking the grandmother and attacking the 7-year-old daughter after that. And so in the end, Jones's conviction and the death sentence is upheld. Justice Sotomayor wrote a dissenting opinion joined by Justice Kagan, and the dissent basically agrees that the lower court below improperly basically ignored the aggravating factors, but Justice Sotomayor's issue with the majority is that the majority went further to then reweigh the aggravating factors against the mitigating factors, which she said was improper. She said what should have happened is the court just says, listen, lower courts, you have to weigh the aggravating and the mitigating factors. You can make credibility determinations, and then you just have to make a determination on if the additional mitigating evidence would have been reasonably likely to avoid the death sentence, and then pass it down to the lower courts to weigh those factors. Instead, the majority did all that, but then the Supreme Court was the one that weighed the factors, which the dissent has a problem with. Justice Jackson also wrote a dissenting opinion in which she said that the lower courts got it right, and she said that the lower court did not ignore the aggravating factors. She conceded that the lower court gave the aggravating factors a bit of a short shrift, a bit of a short analysis, but at the same time she says there's no real standard on how much detail a court needs to go into weighing aggravating or mitigating factors. And so she said what the lower court did was fine by her.
Okay, so now I feel like I have to apologize because I've been recording this over multiple different days, and I just realized that I was filming the phone in vertical and not landscape. But regardless, the next case we're talking about is Trump versus United States. In 2023, Donald Trump was indicted on 4 counts: conspiracy to defraud the United States, obstructing an official proceeding, conspiracy to obstruct an official proceeding, and conspiracy against rights. The indictment alleged that after losing the election, Trump took actions to obstruct the counting, collection, and certification of the election results. These actions included accusing voting machines of being rigged, alleging that massive voter fraud was taking place through the mail-in voting system, hiring lawyers to sue to decertify election results in several state and local governments, declaring that he had won the election before all votes had been counted, and then saying that all the votes counted after the declaration were fraudulent, hiring fake electors in several states to send false certificates, declaring Trump the winner of those states to Congress in the hopes that they would be counted before the authentic certificates, pressuring Mike Pence in declaring the election defective and therefore leaving the election up to the Republican-controlled House of Representatives, calling Republican officials in several states and asking them to reverse the election results to show victory for Trump instead of Biden, and the rally that occurred on January 6th, which later evolved into an attempted terrorist coup. Trump motioned to quash the indictment on a theory of presidential immunity. Presidential immunity is similar to qualified immunity in that it gives presidents immunity from civil or criminal damages resulting from actions they took during the course of their presidency. Interestingly, presidential immunity is not found in the Constitution, whereas legislative immunity is explicitly written into the Constitution. So there is an additional question of whether the framers ever intended presidents to have that sort of immunity in the first place. Nevertheless, the courts have traditionally granted presidents immunity over actions taken during the course of their job, fulfilling their duties as the president. Richard Nixon was the first president whose administration generated several cases clarifying the bounds of presidential immunity. In Nixon versus Fitzgerald, the Supreme Court stated that former or current presidents had absolute immunity from lawsuits that resulted from actions that were within the outer limits of their responsibilities. So in Nixon versus Fitzgerald, what happened was Fitzgerald was a whistleblower in the Air Force, and he was later fired. He sued the government for retaliatory firing and joined Nixon in the suit. And the Supreme Court declared that Nixon was immune from the suit because he was acting within the outer limits of his responsibilities as a president. In Clinton versus Jones, a woman sued Bill Clinton for sexual harassment for behavior that occurred while Bill Clinton was the governor of Arkansas. At the time the suit commenced, though, Bill Clinton was the president of the United States, and he tried to use the defense that he had presidential immunity in that case. the Supreme Court said that presidents do not enjoy presidential immunity for actions that occurred prior to taking the presidency. So the state of immunity at this point is that the president enjoys immunity for official actions, and Trump's team is arguing that the actions he took were at the core of his responsibilities, meaning that he would be immune from suit for them. The district court ultimately denied Trump's motion to quash, and the case was appealed to the United States Court of Appeals for the D.C. Circuit. The Court of Appeals affirmed the decision of the district court, describing Trump's action as lacking any lawful discretionary authority. The Court of Appeals clarified that presidents don't enjoy immunity over criminal actions taken while in office, and that to grant a president absolute immunity over all actions taken in office would collapse separation of powers. The case was then appealed to the United States Supreme Court, and in the Supreme Court, Trump's lawyers argued that the president enjoys absolute immunity for actions taken while in office, with the additional caveat that immunity will be dissolved if the president is impeached. So if the president is impeached for certain actions, then that immunity is dissolved, and he can then be prosecuted for those actions for which he was impeached. Jack Smith, who's the special counsel representing the United States in this case, argued that absolute immunity should not be afforded to the president because doing so would essentially put the president above the law. So what does the Supreme Court say? Well, in a 6-3 opinion authored by Chief Justice John Roberts, the court muddies the waters. The opinion of the court is that the president enjoys absolute immunity for actions taken while in office that are at the core of his responsibilities. So an example of that would be that the president is the commander-in-chief. That's something that's explicitly written in the Constitution. So if Congress declares war on another country and acting as the commander-in-chief, the president deploys troops to that country, but he makes a strategic mistake and a ton of U.S. troops get killed, he can't be liable for that because he's acting at the core of his responsibilities. The court also says that the president enjoys the presumption of immunity for official actions and no immunity for unofficial actions. So the rationale behind the absolute immunity for acting at the core of the responsibilities is that to make a president liable for exercising the authority they're given under the Constitution, either through legislation or through a court opinion, would be a judicial or legislative limit on the president's exercise of power, which would violate the separation of powers. As for official acts, Roberts says that when they're undertaken in accordance with constitutional or legislative authority, the president enjoys the presumption of immunity unless the prosecution can show that prosecuting the president for these actions would not limit the ability of the executive branch to function. And Roberts' rationale here is that the framers envisioned of the presidency and of the executive branch as being sort of the vigorous and energetic, quick-moving counterpart to the slow-moving Congress. And so to keep the executive branch energetic, it can't be hamstrung by fears that it's going to be later liable for actions that the president engages in while in office. The court did, however, explicitly reject Trump's argument that impeachment is necessary to dissolve immunity. It doesn't give any clarifications on if or when immunity can be dissolved, but it does reject the notion that impeachment is the only way to dissolve immunity. The court ultimately declined to dismiss the indictment, instead finding that some actions, such as Trump speaking with his attorney general, consulting with his attorney general on how to strategize to overturn the election results. The court says that that sort of consultation with cabinet members is at the core of the president's responsibilities, and so he enjoys absolute immunity over things like that. But the court remands the case back down to the trial court to make additional findings on Trump's other actions to see if they were official or unofficial acts. Justice Clarence Thomas wrote a concurring opinion in which he questioned the legality of the office of the special counsel and said that if the office of the special counsel is not created either by the Constitution or by any legislation, then it's not a legally created office and that the prosecution cannot proceed. Justice Barrett wrote a concurrence in which she agreed with giving the president absolute immunity over actions taken that are at the core of the president's responsibilities. As for official versus unofficial acts, however, Justice Barrett says that she would have the courts look to see whether the criminal statute applies to the president's action in the first place, and then see if prosecuting the president for that action would limit the functionality of the executive branch. She also made a note that she believes that the president's actions which do enjoy immunity should be able to be used as evidence in a trial for the president's actions which do not enjoy immunity, which is an idea that the majority explicitly rejects. They say, if this goes to trial and some of his actions are presumed to be immune, or if they have absolute immunity, these actions cannot be used as evidence in a trial about his unofficial actions or his actions which are prosecutable. Justice Sotomayor wrote a dissenting opinion in which she criticized the majority for greatly expanding the scope of presidential power and essentially encouraging or opening the door for presidents to engage in illegal conduct, such as ordering assassinations or selling pardons. This is something that Roberts does address in the majority opinion, and he calls it fear-mongering. Justice Jackson also wrote a dissenting opinion in which she also said that the majority's decision greatly expands the scope of presidential authority, but she also says that, she also sort of suggests that the court's decision here manipulates the separation of powers because it's greatly expanding presidential authority and also greatly expanding judicial authority by making the judiciary the gatekeeper of presidential accountability, really, while also sort of shrinking legislative power by limiting Congress's ability to enact legislation, to enact criminal statutes that could also apply to the president. So what happens from here? Well, the case is going to get remanded back down to the trial court. The trial court's going to make findings as to whether some of Trump's actions were official or unofficial. Other actions, such as consulting with the Attorney General, like I mentioned earlier, the majority opinion already says that that was at the core of his responsibilities, so those are going to be absolutely immune. So it's likely that any counts resulting from that conduct, like consulting with the Attorney General, those counts might be tossed. Trump's team is definitely going to argue that this decision throws into question the validity of Trump's indictment as a whole and that the indictment should be quashed. Because the grand jury likely heard evidence about some actions that Trump took, which the Supreme Court later declared as being absolutely immune from prosecution. It's likely that Trump's lawyers are going to argue that the jury is now prejudiced and that the indictment includes information which the president would be absolutely immune from prosecution for. So they're going to challenge the indictment for those reasons. It's likely that it's almost certain that whatever the trial court says, that decision is going to be appealed back up to the Supreme Court, and we're likely going to get another decision sometime soon as to whether the district court made the right decision declaring some acts as official versus unofficial. Because the Supreme Court doesn't really give guidance in its opinion as to what is an official act versus unofficial act. I also noted that the three-tiered structure of presidential immunity outlined by Roberts resembles the three scenarios of presidential actions described by Justice Jackson in his concurrence in Youngstown Sheet and Tube versus Sawyer. Now, in Youngstown, what happened was the president seized the steel industry in order to resolve a labor dispute because he needed steel for the war effort, and the steel workers were on strike, protesting for better wages and better working conditions. The Supreme Court in that case said that the president's seizure of the steel industry exceeded the authority of the executive branch, and Justice Jackson's concurrence said the same thing, but it outlined three scenarios for which presidential action can fall under. And that's Justice Jackson's concurrence is sort of the big takeaway from Youngstown. That's the reason most people cite it today, is for the concurrence. So what are the three scenarios? Well, in the first scenario, the president acts with the express consent of the Constitution or of Congress. In this scenario, Justice Jackson says that the president's authority is at its highest, and his action can only be invalidated if the judiciary finds that the executive and legislative branches as an undivided whole lack that authority. In the second scenario, the president acts and the Constitution and Congress are silent. In this scenario, Justice Jackson says that the president's action lies in a zone of twilight, and whether or not his conduct is permissible needs to be decided on a case-by-case basis, weighing several factors. And in the third scenario, the president acts against the consent of the Constitution or Congress. And in this scenario, Justice Jackson says that the president's authority is at its lowest ebb in the tide, is what he calls it, and that his action will be presumed to be exceeding the scope of executive power unless he can show otherwise. The three tiers of presidential immunity that we get from Trump versus United States resembles the three scenarios of presidential action from Youngstown. However, as I see it, presidential action in the first scenario acting with the express consent of the Constitution or Congress would be the type of action that the Supreme Court here describes as being absolutely immune from prosecution. If he's acting with the express consent of Congress or the Constitution, it's likely that the president is acting to perform his duties under the Constitution or under some piece of legislation. It's likely that the Supreme Court would conclude that the president is absolutely immune from prosecution for these actions. The second scenario that Justice Jackson mentions would likely fall into the second tier of presidential immunity. If the president is acting and the Constitution is silent and Congress is silent, it's likely that these actions would be presumed to be immune as long as these actions were at the very least within the outer limits of the president's responsibilities. A president who acts against the express consent of Congress or the Constitution would either enjoy presumed immunity or no immunity, depending on the specific nature of the actions that the president is taking. For example, Justice Jackson's concurrence in Youngstown says that the president's seizure of the steel mills was against the consent of Congress and against the consent of the Constitution. But even though it was against the consent of the Constitution and Congress, I believe that today's Supreme Court would find that these actions were presumed to be immune because the president is acting at least within the outer limits of his responsibilities. So the president would not be able to be prosecuted for seizing the steel industry. However, if the president sought to overturn or obstruct the results of an election, or if the president sought to conspire with enemies of the United States to harm the United States, or sought to transform the presidency into an authoritarian office, it's likely that the court would declare these as unofficial acts because they're so far beyond the bounds of the president's responsibilities, and so it's likely that the court would say that that the president does not enjoy immunity for these actions. Now, while reading this opinion, I did have the worry that this was going to cause the presidency to balloon with power beyond the reach of the judiciary, and thus beyond accountability. You know, like I mentioned earlier, the Nixon administration was the first administration to really clarify the boundaries of presidential immunity. But I do wonder if today's Supreme Court would see President Nixon's erasure of the Watergate tapes as official actions and thus declare that he enjoyed the presumption of immunity for that action. The Nixon administration also engaged in a campaign to surveil progressive activist groups in America, such as women's liberation groups or civil rights activist groups. And so I wonder if the Supreme Court of today would declare this surveillance as official actions that he enjoyed the presumption of immunity for. The other thing is, what happens when it comes to protests? Can a president violently put down a peaceful protest and then call it an official action and say that he can't be prosecuted for it? You know, these are the type of questions I'm thinking while reading this opinion that I'm worried to know what some of the justices on the court might think. The other thought I had, particularly when reading Clarence Thomas's concurrence opinion, was pertaining to the fact that presidential immunity is not found in the Constitution anywhere. If you know Clarence Thomas at all, then you know his opinions are often fraught with a frantic search to see what the Constitution says. If a right is not explicitly outlined in the Constitution, then Thomas would say that that right does not exist. Yet here, Clarence Thomas is silent to this fact. Anybody expecting some amount of consistency from Clarence Thomas would expect him to write a dissenting opinion in which he says that the president doesn't enjoy any immunity at all because it's not found in the Constitution. In fact, the framers debated whether or not to include presidential immunity in the Constitution and still decided to omit it. So isn't it strange that arguably one of the most conservative justices of the current Supreme Court, who has an almost neurotic obsession with the contents of the Constitution, is remarkably silent as to this fact? A silence which places Donald Trump in a notably better position, a position that would stand to benefit the many donors who fund Clarence Thomas's lavish vacations, and also a position that would stand to benefit his wife, who took an active role in attempting to overturn the election.
Okay, this is a big one. FDA versus Alliance for Hippocratic Medicine. Let's go right now. So this is a case concerning medication abortion, specifically with the drug mifepristone. And so medication abortions are usually performed through a mixture of drugs, usually a mixture of mifepristone and misoprostol, if I'm pronouncing those correctly. And in 2000, the FDA approved the use of mifepristone in medication abortions. In 2007, the Food and Drug Amendments Act, as well as the Food, Drug, and Cosmetics Act were passed, which required the FDA to develop risk evaluation and mitigation strategies to identify benefits and risks of FDA-approved drugs. And in 2011, the FDA developed a REMS for mifepristone, but the availability of mifepristone following the 2011 REMS was the same as the availability of mifepristone following its initial approval in 2000. So, in other words, the FDA develops a REMS for mifepristone, but it doesn't really change the accessibility of it. In 2016, the FDA loosened restrictions on mifepristone so that it could be prescribed, whereas before it could only be administered in the hospital setting. So now it can be prescribed, and it can also be prescribed later in the pregnancy than before. Then in 2021, the COVID-19 pandemic is in full swing, and it's having a really nasty effect on people's accessibility to healthcare. People are having trouble accessing healthcare. So the FDA again loosens restrictions on mifepristone and says that certified medical providers or certified medical businesses can now send mifepristone through the mail to patients wanting to receive a medication abortion. Then in 2022, following the Supreme Court's decision in Dobbs versus Jackson Women's Health Organization, the Supreme Court ruled that there is no constitutional right to an abortion, and following that, several states passed laws restricting access to drugs like mifepristone. Later that same year, the Alliance for Hippocratic Medicine, which is an interest group that advocates for protecting the vulnerable at the beginning and end stages of life, sued the FDA in the United States District Court for the Northern District of Texas. And so their argument here is that the FDA got it wrong from the jump. Basically, that when the FDA approved mifepristone way back in 2000, it didn't properly take into account what the body of scientific literature was saying about the risks posed by mifepristone. And this lawsuit was eventually joined by the American Association of Pro-Life Obstetricians and Gynecologists, as well as the Christian Medical and Dental Associations, and 4 doctors who describe themselves as being pro-life. So the first issue here is regarding standing, and standing is a threshold issue that's going to be present in any case. Standing is another justiciability requirement, meaning that if there is no standing, then a court can't hear the case. And so what is standing? Well, standing is the right of the parties to be involved in the lawsuit in the first place. And in order to establish Article 3 standing, you have to meet 3 requirements. You have to show injury, causation, and redressability. What does that mean? For injury, when you're a plaintiff, you have to show that you are injured or you are at imminent risk of being injured, and the injury has to be particularized, it has to be concrete, and it has to be an injury in fact. So it can't be speculative, it can't be an injury that occurred long ago in the past or anything like that. You have to show that this injury is fairly traceable to the defendant's allegedly unlawful conduct, and you have to show that a favorable court opinion will provide adequate redress for you, and redress is relief. You have to show that if the court rules in your favor, then it's going to fix you and make you right. So in this case, there is some issue as to the plaintiff's standing, because it's several massive associations involved here. Lots of doctors or medical professionals who are being represented by these associations, but it's not clear that the doctors themselves have been affected by mifepristone being able to be mailed. It's not clear that they've suffered any sort of injury. Well, the district court Judge Kaczmarek, addressed standing and said that the plaintiffs do have standing. And so where does standing come from here? Well, he says there are some concerns about potential negative health outcomes that can result from taking mifepristone. And for this, he cites to a Finnish study which compared 40,000 Finnish women who were pregnant, and some of them took mifepristone and some of them received a surgical abortion. And that study concluded that those who received mifepristone were more likely to experience visits to the ER, resulting from complications from taking mifepristone or concerns from taking mifepristone. And it should be noted that these concerns were usually regarding uterine bleeding, that mifepristone was causing uterine bleeding, and that in some of these, in a significant number of these ER visits, there was actually no uterine bleeding, but the concern that there was and the fact that they visit the ER was enough to make it be marked as a negative health outcome in this study. And it should also be noted that one of the co-authors of the study sort of denounced the judge's reasoning and the use of his study and said that isn't really what it stood for. It should also be noted, even though the Finnish study concluded that those taking mifepristone were more likely to visit the ER than those receiving the surgical abortions, the medical incidences were still very low between both groups. These aren't exact numbers, but for example, it's as if out of 40,000 women, 15 who received the surgical abortion had to go to the ER, and 30 who received the mifepristone had to go to the ER, right? You'd still say that if you're taking mifepristone, it's more likely that you'll have to go to the ER, but in both groups, you say that the incidents are so low, 15 out of 40,000 or 30 out of 40,000. So Judge Kaczmarek says, based on this Finnish study and based on some other studies, there is evidence to support this idea that taking mifepristone can result in medical complications, but those complications aren't the injury. The injury happens when those women who are taking the mifepristone experience the complications and they go to a doctor who has some sort of moral qualm or is pro-life and doesn't want to treat the patient or has this dilemma. He says that's the injury that they're suffering. And this injury, he says, is fairly traceable to the FDA's decision to have these loose restrictions around mifepristone, and a favorable court ruling in the form of an injunction on the FDA's mifepristone policy, which would require the FDA to adopt a more stringent policy, that this would be favorable to the plaintiffs. So based on that, he says that plaintiffs do have standing. And then getting to the merits of the claim, he says that the FDA's decision to allow mifepristone to be sent through the mail violates the Comstock Act, which prohibits a number of things from being sent through the mail, one of those being abortion medication. And in addition to the Finnish study that Judge Kaczmarek cites, he also cites two other studies, which I just want to note were retracted by the publisher in 2024. One of them because the methods of the study were too flawed, and then the other one because the author failed to disclose a conflict of interest. Okay, so what happens now? Judge Kaczmarek's opinion goes into effect. The access to mifepristone is more strongly controlled. It's more restricted. The defendants file their notice to appeal to the United States Court of Appeals for the Fifth Circuit, and then they also petition the Fifth Circuit to stay the lower court's holding pending an appeal. So what that would do, if it was granted, is that it would halt Judge Kaczmarek's opinion, and so there would still be greater access to mifepristone until the Fifth Circuit came out with its opinion, and then whatever that opinion was, it would go into effect. So the Fifth Circuit granted a partial stay. They said that mifepristone will go back to its accessibility when it was initially approved way back in 2000. That's the accessibility it's going to be at pending the appeal. And the reason for that is that AHM challenged this in 2020 or 2022 or something like that. And the FDA made this decision all the way back in 2000. So the Fifth Circuit says it's too late to challenge the 2000 decision, so we're going to put that accessibility in place. So the defendants requested an emergency stay with the Supreme Court, and this is all happening in the Fifth Circuit. So the justice who's on circuit assignment in the Fifth Circuit is Justice Samuel Alito, and he grants the stay. What this means, just on sort of a procedural level, is that there's at the federal court, in the federal court system, there's a number of district courts. I believe there's 94, I believe. And these are like the trial courts. These are where trials happen. And if you want to appeal that, you appeal it to a court of appeals, and there's 13 circuits. So all the 94 districts are divided into 13 circuits, and then the Supreme Court justices get circuit assignments. So Justice Samuel Alito is on circuit assignment for the Fifth Circuit. So any emergency petition coming out of the Fifth Circuit will be heard and decided by him and him alone. And so then if that case makes it farther up the Supreme Court, then it will be heard by the court in full. So that's what happened here. The defendants filed an emergency stay with the Supreme Court. Justice Samuel Alito is on circuit assignment in the Fifth Circuit, so he alone has the power to either grant or deny the emergency stay. And he grants the emergency stay. So this means that in the meantime, for now, temporarily, the FDA's 2021 policy for mifepristone is in place. So it's the least restrictive policy, and it can be sent in the mail. Later on, the Supreme Court in full hears the emergency stay petition, and they decide basically to leave the Fifth Circuit's stay in place. So the Fifth Circuit said we're going to make the accessibility the same as it was in 2000, and that's what the Supreme Court says. Pending the litigation, of course. The litigation is still not over. These aren't, when we talk about emergency stays and things like that, we're not talking about, the courts aren't looking at this claim on the merits or anything like that. It's just that this is such an impactful decision that we don't want to keep, taking away access and giving it back, taking away access and giving it back. So we're just going to leave the 2000s initial accessibility in place. That's what's going on. The Fifth Circuit does eventually hear the case in full, and their decision is that when the FDA loosened restrictions in 2016, it did not properly consider all of the literature available, not properly consider all the factors available. So the Fifth Circuit says we're going to keep the access to mifepristone the same as it was prior to 2016. So this would be probably after 2011 when the FDA first developed the REMS for mifepristone. That's the sort of accessibility we're dealing with at this point. The case was then appealed to the Supreme Court, which instructed the parties to prepare briefs and oral arguments only as to the parties standing, as well as the soundness or the reasonableness of the FDA's decision-making in 2016, 2021, and 2023. So what happens in the end? Justice Brett Kavanaugh wrote the unanimous opinion of the court, which concluded that the plaintiffs did not have standing to bring the suit and lifted the restrictions on mifepristone put in place by the Fifth Circuit. So Kavanaugh says that none of the members of the associations involved can prove that they suffered a concrete particularized injury in fact because none of them have had to prescribe mifepristone. And he also addresses the argument that some of these pro-life doctors are going to have to treat patients who are experiencing complications from taking mifepristone. Kavanaugh rejects that idea and says that federal law already provides protections for doctors in these situations. And he also says that doctors have never been allowed to have standing to challenge FDA decision-making on the basis that an FDA policy is going to result in more visits to the doctor. Clarence Thomas wrote a concurring opinion in which he said that he agreed that the plaintiffs don't have standing, and he also said that in the future, in a more appropriate case, it might be time for the court to take a look at association standing, which is sort of a concept in standing where an association who represents a group of people can bring a case on behalf of just one of those people. And he says, AHM represents, tens of thousands of doctors, and most of them have not been injured by the FDA policy. So is standing really there is what he's asking. He would go further, as he often likes to do, and would do away with association standing. So it's like yet again another case where a decision on the merits of the case would have had a really massive impact, there's an important issue involved in all this other stuff, and the court sidesteps it. It's a threshold issue. Standing is important and all that, but I also feel like at times the court is more than happy to overlook standing if the issue is just something they want to decide. Or it could also be that the liberal justices could see the writing on the walls, that the conservative justices wanted to take away access to mifepristone. And the only way to reach a compromise with them where that didn't happen was to sort of focus in on this standing issue and sort of join forces on this standing issue, as opposed to having another divided and fractured court on a very sort of politically and saliently charged issue. It's very likely that this mifepristone issue is going to come back up to the Supreme Court in the near future if the FDA continues to allow it to be mailed, or even if it doesn't continue to allow it to be mailed. It's likely that some doctor is going to say, this contravenes my morals, and I don't want to treat a patient who's experiencing complications because of this, and et cetera, and it goes to the Supreme Court, and then maybe then we'll have a decision on the merits. But until then, we just get another standing issue case. Lindke v. Freed, all my First Amendment heads, all my free speech heads, where you at? Respondent Freed was the city manager of Port Huron, Michigan, and he had a Facebook page with over 5,000 followers, where he posted updates for his personal and his professional life. Petitioner Lindke was upset at how respondent Fried was handling the COVID pandemic, and so he made comments on Fried's Facebook page basically criticizing him, and Fried as a result blocked him. Lindke sued Fried, arguing that Fried was using this Facebook page as a means to communicate, professional activity. So Fried's blocking Lindke was state action, which violated his First Amendment rights to speak freely. So the question before the court, which I think is really pertinent in this digital age, is when does a public official's social media posts or his activity on social media constitute state action as opposed to private activity? Because if it's private activity, if it is really just a private page, you can block whoever you want, even if you are normally a public official. If you're posting, professional updates or things like that, and it could be construed that you're posting on behalf of the state, then we run into some more issues, which is what this case is all about. So Justice Amy Coney Barrett wrote the unanimous opinion of the court, which announced a two-part test for determining if a user's activity on social media constitutes state action or not. The official must, 1, possess the actual authority to speak on the state's behalf, and 2, purport to exercise that authority when speaking on social media. And when determining if the individual is acting on behalf of the state, courts can weigh factors like whether or not the account is designated as a personal account or as an official account, or whether the individual's posts expressed some sort of authority to exercise state power. And in this case specifically, we don't get an answer on whether or not Fried's blocking of Lindke constituted state action. The court basically gave us this two-part test. It said, here's some factors you can weigh, and sent it back down to the lower courts to weigh those factors. So we might be getting a decision on that from the lower court sometime soon, and maybe it'll go before the Supreme Court again. Who knows?
Okay, next up is Moody versus NetChoice LLC. I was also going to talk about NetChoice versus Paxton, but that case got consolidated with Moody, so basically my discussion of Moody is my discussion of Paxton. So Section 230 of the Communications Decency Act provides social media companies with immunity regarding the content that users post on the social media sites. So social media companies can't be sued or held liable for the content that their users are posting. And it also provides social media companies with immunity for content moderation. So they can't be sued or held liable for removing certain types of content from their websites that they deem inappropriate. In 2020, the rise of misinformation in regards to the pandemic as well as in regards to the election caused many social media companies to flag or remove this type of content. A lot of it was also being pushed by conservatives and conservative politicians. So this resulted in Florida passing a law in 2021 that imposed fines on internet companies who banned or who deplatformed a political official for more than 60 days. The law was challenged by the respondent NetChoice, who argued that limiting social media companies' ability to moderate the content on their websites is a unconstitutional restriction on the company's First Amendment rights. So this makes its way up to the Supreme Court, which agreed to hear the case. And so what does the court think? Well, the Supreme Court, which was unanimous in judgment, decided that the appellate court used the wrong standard when reviewing NetChoice's First Amendment claims. Justice Kagan wrote the opinion of the court, which said that the Court of Appeals focused too narrowly on whether the laws were an unconstitutional limit on Facebook's moderation of its homepage content and YouTube's moderation of its homepage content. Justice Kagan says that a proper analysis would have the appellate court looking at the entirety of the legislation and the entirety of the effects it will have, because it will be more than just YouTube and Facebook that's affected, and it will be more than just homepage moderation that's going to be affected. Justice Barrett wrote a concurrence in which she said that NetChoice and other similar companies would likely have a better outcome in court if they challenged certain provisions of these types of laws instead of just challenging the law on its face. Justice Jackson wrote a concurrence in judgment only, in which she said that the majority was deciding more than what it needed to. Justice Thomas wrote a concurrence in judgment only that was basically a combination of the Barrett and Jackson concurrences. And Justice Alito also wrote a concurrence in judgment only, joined by Justices Thomas and Gorsuch, And Justice Alito's concurrence was very similar to Clarence Thomas's concurrence, but with a more cautious tone.
Murthy versus Missouri. So in 2022, after Elon Musk bought Twitter, he sort of collaborated with some journalists to release what he called the Twitter files, which he purports to show government agencies interacting with social media companies like Twitter, sort of asking them to suppress certain content. Usually this content was, suppress content related to skepticism over who won the election, or suppress content related to certain COVID conspiracies or things like that. And so because this sort of skepticism or these conspiracy theories are a lot of times espoused by Republicans, a number of Republicans, including the Attorney General of Missouri, sued the Biden administration, arguing that arguing that these government agencies were coercing the social media companies into suppressing conservative views. So the question first and foremost before the court is whether the government contact with these social media companies resulted in a coerced suppression of views that were oftentimes critical of the Biden administration. If it is coercive, then the court needs to make a decision on what are the lengths that courts can do to prevent government agencies from contacting social media companies. The petitioner Murthy, who's representing the Biden administration here, said that none of the respondents had Article 3 standing to bring the cases in the first place, and that's exactly what the Supreme Court again chooses to focus on. In a 6-3 opinion authored by Justice Barrett, the court determines that the respondents do not have Article 3 standing to bring the case. This is because none of the respondents were able to show that their social media posts in particular were censored or were at imminent risk of being censored, and so they don't have that injury in fact that they need to have standing. Justice Alito wrote a dissenting opinion joined by Justices Thomas and Gorsuch, and the dissent is extremely critical of the majority. The dissent says that the respondents did satisfy Article 3 standing, and it kind of digs into the majority for avoiding what Justice Alito calls one of the most important free speech cases to reach the court in years. Frankly, I read Alito's dissent, and I can't say that I was entirely persuaded by his argument. Perhaps he was too busy appealing to heaven. He forgot to appeal to logic in his dissenting opinion. But what I found most striking is that he included examples of subject lines of emails sent by government agencies to these social media companies, and I just didn't get the impression that they were particularly coercive, or some of them seemed aggressive, sure, but I never picked up on this sort of veiled threat that if you don't go through with this, something bad is going to happen to you. And of course, the threat that Alito and the other conservatives are worried about, or the coercion that they're talking about, is that what they believe is happening is that these agencies are going to the social media companies and saying that if you don't censor these certain views, then we're going to initiate some antitrust suits against these companies and break them out. So I don't know. If you believe that, then you believe that. I don't know. Appeal to heaven, man. Upside down flag, brother. Let's go. Let's get that flag upside down. Okay, next up, one of the big two Trump cases to be in front of the Supreme Court this term. Trump versus Anderson. This is the ballot case out of Colorado. The result of the 2020 presidential election was a victory for Joe Biden, who won by the Electoral College and the popular vote. His political opponent, Donald Trump, continually challenged the result and the integrity of the election, and on January 6th, 2021, he held a rally in which he purported to win the election and encouraged his supporters to protest the election certification that was taking place at the Capitol at the time. Infamously, what transpired at the Capitol on January 6th was a terrorist insurrection aimed at harming or threatening to harm members of Congress to dissuade them from certifying Biden's victory. Now, of course, this event is still very much politically and emotionally charged in American culture, and I'm not interested in arguing about the minutiae of what exactly were the motivations or intentions of the terrorists who decided to attack the Capitol. If you disagree with the way I framed or described the event so far, you're always free to click off the video. So, leading up to the 2024 presidential election, Donald Trump sought to be the Colorado Republican Party's nominee and appear on the ballot for the presidential election. But this caused a group of Republican and unaffiliated voters in Colorado to petition the court to prohibit Trump from appearing on the ballot due to Section 3 of the 14th Amendment. The idea being that Section 3 of the 14th Amendment prohibits former government office holders from holding office if they took an oath to the Constitution and then later betrayed that oath by, for example, spearheading an insurgency to destabilize the already fragile democracy of this country. Just as an example. In order to remove Trump from the ballot, the Denver District Court was required to find by clear and convincing evidence that Trump engaged in insurrection. The Denver District Court ultimately concluded that Trump engaged in insurrection, but that Section 3 of the 14th Amendment did not apply to the president. This decision was appealed to the Colorado Supreme Court, which concluded that Trump engaged in insurrection and that Section 3 does apply to presidents. So the result is that in Colorado, Trump is not going to appear on the ballot in 2024. The case was then appealed to the Supreme Court. And so what are the arguments here? Well, what the respondents are arguing, Trump is an officer within the context of Section 3 because he held office, right? It's a common sense argument. And that, two, his speech was an inciting speech. It was a speech meant to directly incite violence, and so it was not protected by the First Amendment. The petitioners, on the other hand, are arguing that Trump is not an officer within the context of Section 3, and for this they're using a textualist interpretation, which I'm going to explain a little bit more in a bit. But they also say that even if he is an officer, that he did not participate in an insurrection because he gave just a political speech that was protected by the First Amendment and he didn't participate in any of the violence. And third, the petitioners also say that Section 3 is not self-executing, which is another argument I'm going to touch on in just a bit. What does it mean when the petitioners say that Trump is not an officer in the context of Section 3? In order to understand that textual interpretation, we have to read the language of Section 3. Section 3 says, "No person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof." So, in a textual understanding of the Constitution, every word is said to have basically a unique meaning. There's no surplusage. There's nothing superfluous in the Constitution. Everything has a unique and pointed, articulate meaning. And also, the other textual interpretation is that the Constitution follows patterns. So that if in the Constitution it says it makes a list of A, B, and C, that list is assumed to be hierarchical. That A is at the top, B is in the middle, and C is in the bottom, and that other lists within the Constitution are going to follow this pattern. So other lists are going to be similarly A, B, and C, and hierarchical. That's the textualist understanding. So what do the textualists do from there to sort of complete the argument? A textualist would say, well, because all the lists are supposed to be in a hierarchical order, the list in Section 3 does not mention a president. It mentions representatives and senators first, and other members of the legislature before ever mentioning an officer or the language it uses like any executive officer or something like that. So they say in any list in the Constitution, if the president is supposed to be implicated in that list, the president is going to be listed first in that list. It wouldn't be the senators or the Congress people or judicial officers of the state. And so it doesn't make sense that when you see executive officers in the middle of the text coming after senators or representatives, that you're reading into that the president. Because if that were the case, then they would have put president at the top, or they would have simply written president, because they knew they were drafting a constitution. They knew they wanted to have a single member president. So if they wanted to impose some restrictions on the presidency, if they wanted to make sure that nobody who participated in insurgency would ever become president, then they would have done so here, and they could have done so, and they chose not to. So that's what the textualists say. The other argument made by petitioners is that Section 3 is not self-executing. What does this mean? Again, we have to look at the text of Section 3, and the last sentence says, Congress, by a 2/3 vote, can remove any restrictions imposed by Section 3. So the idea is that if they can remove the restrictions by Section 3, then surely they're the body that has to be imposing the restrictions of Section 3 in the first place. There's also a historical argument made by petitioners that after the ratification of the 14th Amendment, Congress did pass legislation sort of setting up the enforcement mechanisms of Section 3. And so the idea is within the greater historical context, it seems that Congress and the judiciary have understood it to be that Congress is the one who enforces Section 3. That's what the petitioners are going to argue. And then in addition to all that, the petitioners also argue that Section 5 of the 14th Amendment says that Congress shall have the power to enforce the provisions of the 14th Amendment. So that's something else that the petitioners or other textualists will like to say makes it so that Section 3 is not self-executing. And self-executing, by the way, means that as soon as you participate in an insurrection or something like that, you can no longer hold office. That's what a self-executing Section 3 would look like. A non-self-executing Section 3, which is what Trump is arguing, what the petitioners are arguing, is that you participate in an insurrection, and then at some point down the road, Congress has to bring some sort of action or pass some legislation or something like that that would prohibit you from holding office, basically. So the Supreme Court, in an unsigned per curiam opinion, says that the courts do not have the power to keep Trump off of the ballot. They basically agree with the petitioners. They say Section 3 is not self-executing. This is a matter left up to Congress, and that this isn't something that the courts have the power to do. And a lot of the per curiam opinion rests on that Section 5, saying that Congress shall have the power to enforce the provisions of this section. Justice Barrett wrote a concurrence in which she agreed that courts don't have the power to enforce Section 3, but she did say that she did not agree with the per curiam basically explicitly saying that the sole enforcement mechanisms for Section 3 come from Congress. She said that we didn't need to decide that at this point. We could have just said that the courts don't have the power to enforce Section 3 and left it at that. And that's what she would have done. Interestingly, Justice Sotomayor wrote a concurrence joined by Justices Kagan and Jackson, basically saying almost the exact same thing that Justice Barrett's concurrence said, that it was enough for the courts to say that the judiciary doesn't enforce Section 3, and that the per curiam did not need to say that the sole enforcement mechanism comes from Congress. And so that sort of gets this interesting question of what was going on behind the scenes. Why do we need two concurring opinions that basically say the same thing? Why couldn't there have just been one concurrence by Justices Jackson, Kagan, Sotomayor, and Barrett? We can always speculate, and that's exactly what I'm going to do. Based on the subtext, it feels like the Sotomayor concurrence is a much more direct criticism of the conservative majority of the court here. The Sotomayor concurrence opens with a quote from the Dobbs case, which, of course, was a case in which the conservative majority, over the objections of the dissenting minority, basically said that there is no constitutional right to an abortion. And so you have this concurrence by Justice Sotomayor opening with a quote from Dobbs, basically putting it back into the conservative wing's face. And it's indicative of almost like a rematch between the conservative and the liberal wings of the court. And it feels like Sotomayor is saying, we haven't forgotten about Dobbs, And then by contrast, the Barrett concurrence more so just comes off as exhausted. It feels like after all the turmoil that's been going on in the court recently, she just wants people to focus on her big takeaway, which is that we got 9 justices to basically agree on the same general concept, that the judiciary does not enforce Section 3 of the 14th Amendment. And she says that's a big enough dub as it is. We don't need to do this thing where we split hairs and have concurrences, which is pointed at Justice Sotomayor. She says, let's just be satisfied with what we have and leave it there. Okay, last but certainly not least, we got United States versus Rahimi. In 2022, the Supreme Court decided New York State Rifle and Pistol Association versus Bruin. The impact of that case is that courts reviewing Second Amendment related legislation have to look to see if that law is in line with the history of gun legislation in the United States. What does that mean specifically? Nobody knows, and a lot of the lower courts are having a total mess out of it, trying to figure out what that means. How far back do you have to go? You know what I mean? How far back do you have to go? Damn. In 2020, the respondent Zaki Rahimi was the subject of a restraining order, which prevented him from, among other things, owning a firearm. Following the court order which prevented him from owning a firearm, Rahimi was involved in 5 shootings. His home was raided where guns and ammunition were found, and he was charged and convicted of unlawful possession of a firearm. And to be clear, the possession of the firearm is unlawful because the 1994 Violence Against Women Act makes it a crime to possess a firearm in contravention to a domestic violence restraining order. So Rahimi appeals this case to the Supreme Court, and he's basically arguing that he can't be prohibited from owning a firearm as a result of a domestic abuse restraining order because that's not in line with the history of firearms legislation in America. So what does the court say? Well, in an 8-1 opinion authored by Chief Justice John Roberts, the court declared that an individual subject to a domestic violence restraining order can be prohibited from owning a firearm temporarily. Roberts clarified that in looking at the history of firearms legislation, courts don't have to find an exact historic match, just something that's relatively similar to the one at issue. And so here we have somebody who has a domestic violence restraining order and they're being prohibited from firearms. Can we find something similar to that in the history of firearms legislation in the United States? And John Roberts says that yes, of course we can find that. There's plenty of examples of classes of people who are deemed to be dangerous to themselves or others being prevented from owning firearms or having their access to firearms restricted. Justice Thomas, who authored the awesome and clear opinion in Bruin, which gave the lower courts a lot of guidance, such as look at the totality of the history of gun legislation. He said that he wrote a dissenting opinion, if you can believe it or not. And he said that, no, I authored the opinion in Bruin, and what I meant was that courts do have to find an exact historical match. It needs to be stricter than what the majority is looking at. And so he says that in his opinion, petitioners did not present that sort of the closeness of the historical match that he was looking at. What is that? Oh my God. No, I swear there's something on the screen. That is so weird. Justice Sotomayor wrote a concurrence joined by Justice Kagan, in which she said that Bruin was wrongly decided, but that the majority was at least trying to offer some guidance to the lower courts. Justice Jackson also wrote a concurrence in which she said much of what Justice Sotomayor said in her concurrence, but she also suggested that perhaps the reason that the lower courts are so confused with what to do with the Bruin decision is the fault of the court, the fault of the Supreme Court for not offering specific enough guidance. Justice Barrett wrote a concurrence in which she sort of sharply disagreed with Thomas, and she sharply diverged. She disagreed with Thomas that courts need to find an exact historical match. She said that doing this would literally take our gun policy back to the 18th century. And also that this sort of way of thinking assumes that the legislatures of those times were exercising maximal regulatory authority, which is an improper assumption to make. And then Justice Gorsuch wrote a dissent in which he agreed with Justice Thomas that courts need to be finding a closer historical match than what the majority describes, but he still says that what the petitioners presented was still a close enough match that he said, yeah, somebody with a domestic violence restraining order can be prevented from owning a gun. So yeah, that's United States versus Rahimi, and I think Justice Barrett was particularly on point with her criticisms toward Justice Thomas, and the one thing that I was thinking about reading Justice Thomas's dissent was this idea of trying to find a historical match of gun legislation involving something with domestic violence, right? Because that's what we have here. We have somebody with a domestic violence restraining order. Can he be prevented from owning firearms? And frankly, you're just not going to find that much legislation on domestic affairs at all prior to like 1975, you know what I mean? So I feel like Justice Thomas's thinking, as it often does, sort of overlooks the adversity experienced by certain marginalized groups in sort of protecting their rights. I mean, it was very recently that courts and legislatures started recognizing that people in their domestic, in their private lives, have the right to be safe and things like that, you know? For a long time, child abuse wasn't criminalized. Child marriage wasn't criminalized, and now there's an effort to bring it back. What the fuck is that about? Child abuse wasn't criminalized. Spousal abuse wasn't criminalized. Marital rape wasn't criminalized until like the 1960s or 70s or something like that. And it's just because a lot of these were seen as like domestic life, which is like a private sphere that the state should have no business being in. And it's also just, I don't know how I would describe it. It invokes a certain feeling in me that this very conservative Justice Clarence Thomas wants to take us back, would advocate for our legislation to be more reflective of an era when the government wasn't involved in private life whatsoever. But he would also, like in cases like Lawrence versus Texas, which involved a Texas law that criminalized homosexuality, he was more than willing to let that law stand. And in fact, I believe he dissented from the majority in that opinion. The majority said that you can't pass this law, and Clarence Thomas dissented from that. So it's strange to me that he's sort of wanting to eat his cake and have it too, or he's eating his cake and wanting to have it too. Because he's like, on one hand, we should go back to an era when the government took no part in your private life, but only when it comes to things like gun ownership and things like that. When it comes to abortion and gay marriage and things like that, then yeah, by all means, let's get the government into private life and things like that. Just some thoughts. I'd be interested to know what you guys think about this case or any other cases I talked about or any of the cases I didn't talk about. I just want to know what you guys think. That's going to be the end of this video. If you did like it, I would really appreciate it if you subscribed and liked the video and shared it and things like that. And I guess I'll be back next year when the Supreme Court finishes up another fantastic term full of great and awesome decisions that nobody has an issue with.
The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oh, yea, oh, yea, oh, yea. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.